I almost dropped my coffee when I saw it. 96 houses were being built beyond my property line. At first, I assumed the developer knew exactly where the boundaries were. That assumption turned out to be very expensive. The more I looked, the worse it became. Several roads appeared to cross directly onto my property. Entire foundations had already been poured. Something wasn't right. The project was enormous. Hundreds of workers were moving nonstop. Millions of dollars were already invested, and nobody seemed aware of the problem. That evening, I pulled out my survey records. I checked them twice. Then I checked them again. The numbers confirmed my worst suspicion. The development wasn't near my property. It was partially on my property. The mistake wasn't a few feet. It stretched across a huge section of land. Before saying anything, I hired surveyors. I wanted absolute certainty. If I was going to make a claim, I needed evidence nobody could dispute. For 2 weeks, they measured every corner, every marker, every recorded coordinate. The final report was devastating. My attorney reviewed the findings. Then he looked at me and smiled. That usually meant one thing. The law was on our side. Meanwhile, the developers celebrated progress. Homes were selling quickly. Buyers were signing contracts every week. Nobody suspected a storm was coming. I could have stopped construction immediately. Legally, I probably should have. Instead, I chose patience. And that decision would change everything. Once the survey was complete, there was no room for doubt. Several roads, lots, and foundations sat on my property. The evidence was overwhelming. Now it was time to decide what to do next. My attorney gave me several options. We could file an injunction immediately. Construction could stop the very next day. But I had a different strategy in mind. Construction continued at full speed. Every week more homes reached completion. Millions of dollars were being invested. The developer remained completely unaware. Some people would have confronted them immediately. I chose patience instead. The more work they completed, the harder it would become to ignore the mistake. While construction moved forward, we gathered every property record available. Deeds, plats, surveys, and county filings. Each document strengthened our position. Then we found the original deed. It clearly described the boundaries. There was no ambiguity. The land belonged to me. Meanwhile, sales continued. Families were buying homes every week. Marketing campaigns promised a dream community. Nobody knew a legal disaster was approaching. The developer believed everything was going according to plan. Deadlines were being met. Investors were happy. Profits looked stronger than ever. Once enough evidence was gathered, we officially filed our case. The lawsuit wasn't complicated. It simply asked the court to recognize the actual property owner. The reaction was immediate. Executives who had never worried before suddenly looked concerned. The survey maps attached to the lawsuit were impossible to ignore. For the first time, panic entered the room. An emergency meeting was called that same week. Lawyers examined every document. Surveyors checked every measurement. Unfortunately for them, the facts weren't changing. As the first court date approached, the developer finally understood the seriousness of the situation. The project they thought was secure had become a legal nightmare, and the biggest revelation was still ahead. A few weeks before trial, something unexpected surfaced. During document discovery, thousands of internal files were reviewed. Buried among them was an old warning, and it changed the entire case. Years earlier, one engineer had raised concerns about the property lines. He recommended a full boundary review before construction began. His warning was documented. Then it was ignored. The discovery created serious problems for the developer. They could no longer claim nobody knew about the risk. Someone had identified the issue from the beginning. Management simply chose not to act. When my attorney read the memo, he immediately recognized its importance. The document established prior knowledge that could influence how the court viewed the entire dispute. Shortly afterward, the developer requested negotiations. For the first time, they seemed interested in resolving the matter quietly. The confidence they once had was fading. Several proposals were discussed. Some involved purchasing the disputed land. Others suggested complicated easement arrangements. But none adequately addressed the situation. I wasn't interested in rushing a decision. The issue wasn't just money. Ownership matters. And the facts still deserve their day in court. Trial day finally arrived. Years of construction and months of legal preparation had led to this moment. Everyone knew the stakes were enormous. The courtroom was packed. The expert testimony was precise and detailed. Survey maps were displayed for everyone to see. Measurements, coordinates, and legal descriptions all pointed to the same conclusion. The disputed land belonged to me. As the evidence accumulated, the atmosphere in the courtroom shifted. Questions became harder for the developer to answer. Their earlier confidence had disappeared, and the most dramatic testimony was still ahead.